Australian child visas. Child visa applications may be made outside Australia or inside Australia. Relationship. The child must be sponsored by the parent of the child who is an Australian citizen, a permanent resident, or an eligible New Zealand citizen. The child must be either the biological child of the parent or an adopted child or a stepchild of the Australian parent. If an adopted child is applied for outside Australia for a child visa, the child must have been adopted before the parent became an Australian citizen or permanent resident or eligible New Zealand citizen. If the child was adopted afterwards, they should apply for an adoption visa. Relationship status. The child must not be married or in a de facto relationship or engaged to be married. And if the child is over 18 years old, the child must never before have been married or in a de facto relationship. Age. Generally, the child must be under 25 years of age, but if they are over 18 years of age, they must be a full-time student and financially dependent on the sponsor. The only exception to this is where a child has a disability that stops them from working. The parental responsibility, that is custody, requirement must be met for every child under 18 years of age. If another person has legal custody, their permission for the child to migrate must be obtained from that person. If an applicant is under 18 years of age, the sponsorship cannot be approved if the sponsor or sponsor's spouse or de facto partner has a conviction for offences against children. The applicant will also need to satisfy the requirement that there is no strong reason to believe that the grant of the visa would not be in the best interests of the child. Dependent children or partner visa applicants. A dependent child who has a parent holding a temporary partner visa, in other words a temporary partner visa subclass 820 or a provisional partner visa subclass 309, may apply for a temporary dependent child visa, which is a subclass 445. Subclass 445 visas are only for children of temporary partner visas. These temporary visas allow the child applicant to enter and remain in Australia until a decision is made on the parent's permanent partner visa application. The subclass 445 is for a child who was not initially included in the original prospective marriage visa or partner visa application of his or her parent. After the subclass 445 visa is granted, the child should immediately apply for the permanent partner visa of the same class as their parent. It is essential that this is lodged before the decision is made on the parent's permanent partner visa application, as the subclass 445 will automatically cease when the parent's permanent partner visa is granted. If not, this may result in the child becoming unlawful in Australia or the child not having a permanent visa option. Thank you.